Today is November the 5th, 2020. Welcome to the Board of Education meeting. This one's going to be a little bit different. Not going to talk about resolutions that involve finances or curriculum, lesson plans, and teachers and who we should hire and what our financial situation is. This is a little bit different. Today, the board decided quite a while ago that we needed to map out a plan for our own professional development. How do we become better as a Board of Education? And one of the ways you do that is you get training. You get training by people who are experts or knowledgeable in certain areas. For today, for example, we are having the opportunity to receive some professional development or training from a guy that some of you may know pretty well. His name's Carl Christoph. He has got years in this business and knows a lot about school boards, districts, New York State law. He's a lawyer by trade. And we are very, 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 very fortunate and blessed to have him as a member of our team on a day-to-day operational basis. But we're also very blessed to have him because he is a great teacher and a professor of various aspects of the law and of the laws that relates to education. So without further ado, I offer for my colleagues and the board offers to the community an opportunity for you to learn about school boards and how they relate to superintendents and what the powers are of school boards and what the powers are of superintendents and how those two groups of folks, boards and superintendents, can work together collaboratively and effectively consistent with the law. So without further ado, Carl, as we say here, the gavel is yours.
Thank you, Mr. President. To begin with, a couple of comments about the title slide. It says governance versus management. I didn't make that one up. That appears in a number of various reports that have been written by the district and so forth. Probably a better title might be governance and management. Governance is something, of course, that the board does, but management is something that the superintendent does. Hence, our concentration on the board and the superintendent in terms of what they each do, and that's primarily going to be the topic. Now, one other thing about the title slide, it perhaps ought to have an addition. The addition would be another dash, would be dash a legal perspective, because I don't intend for this to be the be all and end all about the relationship between the board and the superintendent. However, in as much as that relationship is born in the law, is maintained under the law, and sometimes, unfortunately, even is dissolved according to the law, I think the legal perspective is important for all of us to be aware of. I'm going to also begin by hitchhiking on something that Vice President Elliott added to the last meeting of the board, and which various board members from time to time have inculcated, and that is that relationships matter, and that many times various activities of board are all about relationships, and strong relationships produce strong results. That's another common thing that's shared amongst board members. And I'd like to suggest before we get started that given everything that is going on in this district right now, those relationships probably could not be more important. So with that said, in terms of an overview and what we're going to talk about this morning, there'll be a few things that I found over the years to be true. We'll certainly, since this is a legal perspective, we'll talk about the law. And the roles and responsibilities of the board and the superintendent under the law. I'm going to share then also some specific instances, some examples, 6 in all actually, of how that relationship works under the law. And then maybe I'll stray a little bit from the law, although I hope you'll see that it has some relevance to the law, and those are some practical considerations. Again, those are pretty much observations of mine in applying the law to this relationship over the years. And then hopefully there'll be some time for questions. But with respect to the questions business, and so this doesn't turn out to be more of a speech than I would like it to be, If there is a question that anyone has as I'm moving through these various slides, please just speak up and we'll try and answer it as we go. So with that said, on to the truisms. One of them is, of course, dates back to the law of kings, where there used to be a sovereign in whom all power resided. Well, the state's that sovereign in New York. And as a result, school districts and school officials like the superintendent exist only because they were created by the sovereign. The district, the board, the superintendent, in and of themselves have no inherent power. Another way to put it is that a school district is an entity of delegated power. The power, of course, is delegated by the state legislature. The board, of course, is a corporate entity. We've heard this many times, and the power of the board belongs to the body and not to any of its members. And there's a nice little quotation from the 37th edition of school law that tends to illustrate that. Same thing with board members. Board members don't have individual authority to act, but there is an exception that's buried within the quote there. And that's the exception that the board, when it takes official action to designate one of its members to do something, that member acts with the power and authority of the board. An example, for example, that we do here is that various board members are granted responsibility with respect to certain schools. And with respect to those schools, the board has clothed the various representatives with the authority to visit and ask questions and interact with folks and so forth. That certainly is a good example of this principle. The superintendent, of course, is appointed by and reports to the board. We know that. But in Rochester, there's another kind of exceptional situation that applies only to Rochester and the other members of the Big Five school districts. And that is that the superintendent is an actual member of the board. It's not strictly as much of an employment relationship as one might think. The superintendent has all the authority that a board member would ordinarily have to participate in the meetings and to discuss, and not necessarily to speak only when spoken to, except perhaps when parliamentary procedure would require that. That's a pretty important distinction. Another truism under the law is that the superintendent is bound not only to the board by virtue of employment, but also has an obligation to the state by virtue of the certification that the superintendent must hold in order to occupy the office. That's also important to remember. So again, this is not the traditional employment relationship. But again, the relationship part of it is really what counts here. So what does the board get to do? Well, we know about some of these things. The big four here are on the board: preparing the budget, establishing policies and adopting bylaws, rules, and regulations. And skipping on down to the second from the bottom is to employ professional and support staff. That means appointing people to employment, granting them permanent, if you will, status, sometimes known as tenure. And that applies to both professional certified staff as well as the paraprofessional support staff and other members of the groups of employees that work for the district. With respect to that second last bullet, we'll get to that a little bit more in covering the examples, in as much as the relationship under the law between the superintendent and the board is very unique here. So what do superintendents do? Well, superintendents are essentially about implementation and enforcement of those policies and so forth that are established by the board. Superintendents recommend curriculum and so forth. They certainly supervise and direct the program. They manage district personnel. They are an enforcement authority with respect to the law. related to the operation of schools. And of course, we have the ubiquitous other duties as assigned. All of that happens, however, and this is specific within the law, under the direction of the board and subject to the board's bylaws. That's always the overriding piece that we have to keep in mind in talking about the relationship. So, kind of comparing the roles and responsibilities in another fashion, the board is about ends. You know, what is the end state, as folks in the military like to say sometimes when they're faced with a battlefield and a legislature that sends them to war. You know, the good general officer always asks, what does the end state going to be? You know, what does the battlefield look like after we're gone? And that's the responsibility of the legislature, the board, the folks that dispatch the superintendent. But the superintendent focuses on the means. And when the board migrates over to that second column and starts talking about the means, that's when that notion of micromanagement creeps in. The board also addresses what? The superintendent how. The board addresses why. The superintendent when. The board how well. The superintendent where. The board also, and we're seeing that a lot these days, concentrates on the how much will it cost, while the superintendent, on the other hand, legitimately has to determine who can do it best. Of course, the board has some concentrations on the vision, the goals, the policies that it enacts. The superintendent concentrates on the objectives, the plans, and the action necessary to accomplish them. Yes, ma'am.
How well are we doing this? How well are we staying in our lane and not getting in the lane of the superintendent? Do you have an assessment of that, or is that too premature of a question right now, or is it an appropriate question? But
I don't think it's ever an inappropriate question, and it's a good one. I think the board, in terms of continuous improvement, is getting better and better at this. But it's something that you always need to keep in front of you. That's a very legitimate question.
Okay. Should we do like a survey? You know, we do these meeting surveys. I'm wondering if we should do some kind of survey with regard to this interaction.
Well, some boards participate in a self-assessment process, and the board is moving in that direction. You know, just utilizing the survey, you know, that you all critiqued the other night, you know, that you do after each of your meetings. If you broaden out that kind of self-assessment, as some boards have done, you will have normally a question that deals directly with, you know, how well are we staying within our lane, and that's a good thing to do. And you know, and our superintendent, as a board member, quite legitimately, and I really believe that if she was feeling pinched in this regard, she would do this. She certainly has the ability to say, you know, hey folks, this is a matter of means, not ends. You know, I'm still, you know, steering the ship here. You just tell me in what direction you want it to go.
Thank you.
Yes, ma'am. So some examples. The first one has to do with the appointment of folks, teachers, administrators, and other certified staff, particularly. And that is a matter of shared authority. That's where this relationship is really unique, because it does take two. The superintendent has to make a recommendation, but generally, the board can't appoint anyone without that recommendation. Now you'll see the parenthetical there after the but, that generally occurs is when the superintendent makes a recommendation and the board doesn't act by a given time, and there you run into things like tenure by estoppel. So that's the reason for the parenthetical. Now, on the other hand, considering the shared nature of the relationship, the board has to pass a resolution but can only act on those persons that are recommended by the superintendent. So it takes two. The superintendent can't appoint on her own, but on the other hand, neither can the board. The superintendent must make a recommendation. That's what lawyers like to call the condition precedent. And the board must act on that resolution by passing, or on that recommendation by passing a resolution. Now, that's not only true with respect to appointments. It's also true, as the slide suggests, on terminations during the probationary period particularly, and very importantly for the granting of tenure. This same process has to take place. There has to be a recommendation and a board action, and without both, nothing can happen. Collective negotiations, another example. Again, another example of shared authority. The contract, as we've mentioned before, is actually between the superintendent and the union. I mean, that is literally under the law. That's nobody's interpretation. There is a section of the law that specifically says that. However, under the statute, if the new contract costs an extra nickel, the board has to allocate the funds to fund that contract. And so the contract doesn't happen again without two things. The superintendent gets to negotiate the contract, and the board has to legislatively approve it. We often deal with the notion of administrative leave. And I want to tell you a little bit about the derivation of that term. There is specific authority in the law for the superintendent to suspend folks. Suspension is kind of from a connotation standpoint, a pretty negative sort of thing. You know, you think about suspension and you think it's an adverse action. It's because somebody did something wrong. And of course, as we've talked about before, just because someone happens to be put in a leave status while an investigation or something like that happens, doesn't mean that the person's guilty of anything. It's just that we have an allegation that's sufficiently merited or serious to merit an investigation. So some years back, in a fairly high-profile case that I was handling for Buffalo, I coined this term administrative leave, and it just kind of caught on. But the same rules apply here with respect to administrative leave as apply to suspension. And that is, it's imposed by the superintendent, but only until the next regular meeting of the board. And at that meeting, what happens is something that I call a report item, that all the facts are reported to the board. And then the quote there is for its consideration and action. Well, what does that mean? Does that mean if nothing has to happen other than the administrative leave continuing, that the board's got to pass some resolution? Well, no, not in this circumstance. The action that's contemplated is the action to end the leave status and bring the employee back. The board can actually decide to do that, although I would suggest that in most all circumstances that would not be advisable, because any responsible superintendent who puts someone on administrative leave means that they should stay there until whatever investigation or other process is going on is done. But in any event, that's the consideration and action. And usually, of course, all of that takes place in executive session because we are certainly interested in not unduly ruining the reputation of anybody who may be in that status. Course content and textbooks, that's something that the board has a lot of say concerning, but it's preceded by the recommendation of the superintendent. And then there is a resolution to adopt that recommendation by the board. And of course, the implementation at the end of the day is the superintendent's. So again, there's that kind of marriage that must happen between the board and the superintendent in order for this particular role and responsibility to be performed in the way that it ought to be. Another example is the commencement of legal proceedings. Now that one normally starts with the board's action. Usually the superintendent will recommend it, but sometimes the board on its own will elect to do so. You may recall that we had a little dispute with the city not too long ago with respect to the very existence of the board. And that proceeding was started with a resolution that was adopted by the board. But it's not that the superintendent doesn't have a role, because when it comes to implementing that board action, by authorizing and granting resources to the board's attorney in order to conduct the legal action, that's in the superintendent's ballpark. And so again, it kind of takes two, although this time we start with the board sometimes, and sometimes the superintendent, of course, incidentally, certainly has the ability to recommend that a legal proceeding be commenced, which then would be done, but again, only with the board's action. It takes two in that circumstance. Sometimes there are problems with teachers and administrators or staff that come to the attention of a board member. The board member could be in the grocery store, or perhaps visiting one of his or her assigned schools, and this kind of problem comes to the attention of the board member. Well, what should the board member do? Well, the board member ought to remember it's the superintendent that answers directly to the board. And in that circumstance, therefore, the board ought to raise that concern with the superintendent. And again, executive session is the place to do that. And doing that is a good way to avoid micromanagement and so give the superintendent the ability, which she has under the law, to manage the workforce. So some practical considerations. These, I confess, are not altogether related to the law, but some of them are. And it starts with one of my favorite Samuel Goldwyn-isms, and that is that a verbal contract isn't worth the paper it's written on. If the relationship means anything and you're going to have a contract, it has to be more than the shaking of hands, because it grants a great opportunity to establish right at the outset of the relationship what the goals and objectives ought to be, and it clarifies the various lanes, that Vice President Elliott was talking about before, in terms of where does the board get to drive, and where does the superintendent get to drive. The contract should provide therefore some clearly defined roles and responsibilities, and this is something, again, kind of related to the question Vice President Elliott raised before, to something that you all do and do here, I think, pretty well. Because if you take a look at attachment 1 of the current superintendent's contract, you will see that it is all about the roles and responsibilities of the superintendent. Continuing, of course, and now we're starting to range a little bit beyond the law, although there are circumstances under which contracts are litigated, and oft times one of the determinants of that kind of litigation is whether the parties are communicating. And in communicating, it's more than talking to one another. It really is about seeking understanding. You may not agree on everything, but you ought to at least fully understand what the other person is trying to accomplish, and the means by which the other person may think it ought to be accomplished. Even though you may not agree at the end of the day, communication really doesn't happen unless there is mutual understanding of one another's positions. That, of course, as the slide suggests, leads to successful implementation of policy and the best programs for students, which at the end of the day, of course, is what we're all about. That trust and confidence, though, also leads to public trust. You would be surprised, and maybe not, the extent to which the public really pays attention to what the board is doing and what the superintendent is doing, and most importantly, what they are doing together. The trust in the institution is really at its highest point when the public perceives that there is a solid working relationship between the superintendent and the board. It shouldn't be this. I suppose the two bears ought to be hugging each other if this was in the, in a better, when you're in the crosshairs, you don't try and pass blame along, but rather you have one another's back. You know, with the ultimate goal, and again, this isn't really a legal thing, and maybe even against the self-interest of lawyers, but the goal ought to be that the law just doesn't really have to be matter. It doesn't matter, and it shouldn't be, you know, consulted about with respect to every decision, because there is a sufficient solid relationship that the parties just don't have to be concerned about whether everyone's in their own lane and so forth. When that exists, that's when the place really hums, I would suggest, and certainly I have seen that over the years. Yeah, it is a lot about the tone at the top. Culture matters, and this is something that the board works on quite a bit, much to its credit. And you know, there are certain things in these slides, you know, where I'm going to take the opportunity to, you know, pass along, you know, some kudos where they're deserved, and this is one of them. The board, I think, has become more and more conscious over the years in terms of that tone at the top. How do we portray the institution when we're meeting in public session and God and everyone's watching? You know, the elements are obvious and you know, needn't be reviewed any further by me. So what happens though when the team isn't working so well? Well, a lot of this has to do with things that the district inculcates, and that's restorative practice. And it starts a lot with open communication, as we talked about. That's absolutely critical. The parties have to understand one another. And then sometimes the way, you know, you solve a particular problem is in a retreat format. The board has certainly engaged in retreats before. You focus on the problems pursuant to some ground rules, and it's not subject to the open meetings law. This is something where the board can meet off the record, if you will, you know, and the parties can kind of let their hair down and have a real good, frank discussion to try and resolve the matter. If something more formal is required, you know, either by virtue of the board being convinced that you know, there's a better way of doing things as suggested by the superintendent, or maybe because the board believes you know, that it's in the right. Well, sometimes the way you have to do that is to clarify your bylaws. It's a formal process. The open meetings law does apply, and you know, the board has engaged in that process itself. You know, again, I think much to its credit with respect to the conduct of board members. You just very recently established a board protocol in terms of, you know, how you interact, and you have certainly used a facilitator. Again, a very good way to proceed in this kind of circumstance. Identifying core values, of course, communicating them. You know, the board's been working very hard on that. Once they're done, of course, it's important to live them. And we talk about accountability a lot too, you know, particularly among leadership. And that really flows from these three elements. You have to be definite. People need to know what the expectations are. The expectations need to then be assigned clearly. And of course, you need to check. You know, the old saying, you know, that which gets measured gets done. This is also awfully important in terms of a legal concept of due process. You know, and everyone thinks that's a, you know, very complicated thing, but it only really boils down to two things. First is notice concerning your expectations. And the second thing is an opportunity to have that discussion about those expectations. That's really what due process boils down to in the last analysis. Lawyers like to say it's notice and an opportunity to be heard. The beat the kid home quote is something that I learned from an experienced principal years ago, who told me that whenever he would have a problem with a youngster in school, it was always his object to get in contact with the parents before the kid got home, because he wanted the parents to hear his version before he heard the kid's version. Well, that's true in the communication business in general, I would suggest, and the relationship between the superintendent and the board. Each one ought to try and beat the kid home in terms of, when something goes wrong. And when you have that discussion, you need to talk about the whole shebang, the good, the bad, and the ugly of whatever it is, that may end up being the crisis du jour. I think the board president here just earlier during this meeting talked a little bit about continuous improvement, and which all involves the setting of the ends and not the means, and from the board's perspective. The last quote there, the presumption of regularity, is something that I learned very early in the law business when I was in the litigation world. One of my seniors at that point told me that when our firm sends a lawyer to court, that lawyer is always accompanied by the presumption of regularity, which meant that the judge, when he sees where you're from, will presume that your papers are factual, that the law that you cite is actually the correct law, and the judge will continue to engage in that presumption until that presumption is rebutted or proven to be wrong. And that presumption of regularity is something that I was instructed to dearly guard, because the reputation of the whole firm depended on judges regarding our lawyers in that way. Well, I think it's true, that same presumption I think ought to apply in the relationship between the board and the superintendent. Each ought to treat the other with the presumption of regularity. When the superintendent brings the proposal to the board, the notion shouldn't be to look behind it. The notion should be to take it on trust because you hired the superintendent because of her expertise. The other way around, when the board advances some object that it would like the superintendent to accomplish, the superintendent should treat that object again with the presumption of regularity. Now, the object may end up not being valid, and the superintendent may very well say, well, there's another better way of perhaps to approach the same problem. And again, that's what the superintendent is paid to do. But at the outset, the presumption of regularity should apply. And as the slide suggests, it runs both ways. Expecting accountability, sure. Stuff that's tangible, concrete, specific. Y'all just went through the process of doing that in the goal setting exercise that the board undertook. And the instrument that you use to evaluate the superintendent contemplates exactly this kind of approach. This next bullet is something that both the board and the superintendent do regularly and very well. And again, just really is here to reinforce what I see as very positive conduct on the board's part. The board goes out of its way to thank folks, and so does the superintendent. And rarely ever do you see either of them seeking the credit, but rather they grant that credit to the folks who sometimes are the ones who actually make the event happen. And of course, the board is the Board of Education, and we never should forget that we're really here to educate the children that are entrusted into our care. So, some conclusions. I love this Daryl Zanuck quote. If two men on the same job agree all the time, then one of them is useless. If they disagree all the time, then both of them are useless. Folks, this relationship is not about agreeing all the time. And it's not about disagreeing all the time. It recognizes that there can be disagreements some of the time. And actually, and I think if you actually did an analysis of the board's resolution, you'd see that the agreement happens most of the time. And that leads again, or leads to the Henry Ford quote, which I'm sure you all are very familiar with. Coming together is the beginning, keeping it together is progress or process, is a process, working together is success. And again, that, that's really what this relationship should all be all about. And finally, one of my favorite quotes: "If at first you don't succeed, you'll get a lot of advice." Thanks for taking the opportunity to consider this advice tonight. And if we have any questions, now's the time.
I do.
Please.
I don't know if you're monitoring the hands up, so I thought I'd.
No, unfortunately, I can't see the hands up.
All right, so.
Someone was kind enough to take the presentation off the board.
Very good.
I got you, Carl.
Oh, thanks.
Back on the slide that referred to adopting textbooks raised two very different questions going in two different directions.
Mm-hmm.
So one is we adopt a textbook and presumptively a curriculum as a body, and we also approve the expenditure of funds to buy those textbooks. What happens at the other end of the life cycle? I remember years ago, we the board was informed of essentially an auction of obsolete items, supplies, assets. And I think there is a market for used textbooks somewhere in the world, but is a resolution required to dispose of textbooks, or is a resolution required to authorize an auction of obsolete equipment and supplies?
Yeah, it's kind of implied in the law, actually, and it's implied from the provisions that deal with real estate, which of course we don't have much responsibility for in the city district. But basically the notion is you pass a resolution that has two parts. The first part declares the property, whatever it is, of no longer being of educational use or value. And the second part authorizes a sale under whatever circumstances, the sale should be authorized. Over the years, in Rochester, as I understand it, that authority has sort of been delegated to the administration. And the administration from time to time, I understand, conducts those kinds of things and reports back to the board with respect to, how successful they were and the money that was raised and so forth. More recently, I think also there have been donations that are made to various organizations, seeking not to make money from an organization who otherwise, really needs the asset. And it being of no further use or value to the district, the donation is without value, at least to us, but very valuable to the recipients. But I hope that answers the question. The law is not clear as a bell on this, but I have not seen that authority exercised in a manner that's other than prudent. Since I've been here.
Well, I mean, certainly the of educational purposes has direct bearing when we're talking about turning over our buildings back to the city. We have to certify that they are not being used for educational purposes anymore. And if we just have a dispute over whether that whatever purpose it is or isn't educational, that could be a holdup.
But there's a very nice presumption that runs in favor of the board in that kind of dispute. Okay,
but the thing is, how do we document that something is of no value? I mean, we do keep in a private company, you would keep a record of depreciation and would have a ledger that shows that it is fully depreciated and is only a salvage value. How's that determined in the school district?
Well, I can't answer in every circumstance. That's a little bit beyond what I do here. But I can tell you what I think I have observed over the years is that, you know, a lot of these things happen in the facilities area because the chief operating officer has a lot of responsibility for our property. And they often will consult the market to see, you know, what the market value might be of a given thing. I think that happens also in the textbook area. Probably, if anything, we warehouse a lot of stuff that we don't need anymore. Because I remember when I visited the Martin Street process place not too long ago in the context of the litigation, there were pallets of stuff that was just, you know, so old. I mean, it had just been left there years and years ago by somebody. And if there was anything of no educational use or value, boy, that was the stuff. And there was a lot of it.
Right, and some of it doesn't even have a secondary market for if it's.
Oh, this stuff wouldn't have.
If it's old enough, it's not even useful for landfills. But so
let me for a moment though defer to the superintendent because she may know more about this than I do.
Sure, as far as textbooks, certainly you know that within New York State we've had shifts from the Regency. From the Regents reform agenda, then it was Common Core, and now we're in next. Oh, you moved over here, Will. I'm Commissioner Powell. I'm sorry, I was looking down. So certainly when those major shifts happen, which is outlined by the State Education Department, then we do need to make some changes. Obviously, if we're starting a new course, we need to have new textbooks, but certainly if things start to become historically, you know, inaccurate, I'm looking now in the social studies department, right? If things are historically inadequate or does not reflect contemporary best practice in the subject area, then we would need to change.
And I know I'm going a little bit down a rabbit hole here, but the other thing I was thinking about was that boards over the years have tied themselves in knots over the question of whether to charge students for lost textbooks. Where does is that a board decision or is that an administrative function? Because we do have.
I do not know the answer to that off the top of my head. I would think that it would be a board decision to begin with, pursuant to a policy, and that then, of course, the superintendent would be the individual that would implement that policy. I haven't looked at that question because it's not been asked before, so I don't know whether either the policy exists or doesn't.
There's also a lot more, there's movement and more resources around online content, right? So that avoids the losing of the textbook. But I would think it, similar to what Carl said, that if we wanted to charge, the board would have to weigh in.
Right.
I suppose this, you know, aside from textbooks, I mean, it could probably apply to graphing calculators, you know,
laptops, Chromebooks, iPads.
Yeah, that we buy for folks. I don't know that the board necessarily has a policy on that or would want to, you know, because just think of implementing it. There would have to be an investigation with respect to every case. There would, I imagine, have to be some kind of culpability determined. There would be a certain amount of process that would be associated with that. And then you'd have to reduce the thing to a judgment, perhaps, and you know, then enforce the judgment. I don't know if you wanted to go down that path unless we had some really large problem, you know, where we, you know, had an epidemic of, you know, lost calculators and iPads and so forth, and you know, we were really starting to, quote, lose money, if you will, on the proposition. I wouldn't advise the board to go in that direction unless that situation existed.
Yeah.
Well, yeah, and I don't think it hasn't come up on this board for years and years, but I do remember that in my growing up years that, you know, we didn't get our grades for the finals marking period until all of our books were turned in. You know, in some cases you can't walk the graduation stage until all the books are turned in. And that's easily enough done in smaller districts where the whole question of accountability isn't as onerous. There aren't as many students to keep track of.
Yeah, another common example was the practice of we won't send your transcript to a school that you're transferring to until you do this, that, or the other. I can tell you with respect to that example, that's unlawful. You don't get to do that.
I see Ricardo has raised his hand.
I've been thinking about this, PD, all day when you speak about relationships with the board and superintendent. And I've observed a lot of different superintendents, but I've never been a part of hiring one, except for Dr. Smalls. And because I wasn't here for Terry Dade's bringing him in. And we actually had reached out to her. She didn't really come looking for this job this time. We reached out to her and asked her for the job. And I recall it was really a crisis time here in the district. It's still a crisis time, but it was a crisis time in the district. And so I remember calling her and telling her that I would support her if she took this job. I really was hoping that we didn't have to go through that whole thing again. And she did. And today, looking at this thing coming up, I had to look at myself and ask myself, am I living up to my own expectations or the expectations that I told her that she could depend on me supporting her? And so I just wanted to say, it's just my way of saying I'm getting on track. I got to get on track here. And Dr. Smalls, I just need you to know that nothing has changed since that first interview. I do support you. I cannot be a success without you being a success. And so I just needed you to know that. It's been on my mind all day. And that's what I have to say. I support you.
Thank you, Commissioner Adams. That means a lot. I appreciate it.
You know, that's a great phrase, though. Commissioner Adams, if you don't mind, if I give this presentation elsewhere, which I may very well, because from time to time, folks do ask me to talk about things like this, I'd like to steal that one. The board can't be a success unless the superintendent is a success, and vice versa. That's a great saying. I want to hang on to that one.
Any other questions or comments for Carl? All right. Well, Carl, well done. Thank you very much. I hope some people were listening beyond just the board members. It doesn't escape anybody. We have elections coming up in 3-4 months. And this would have been a good lesson for folks to listen to if they're interested in running for school board, because it described principally the role of board members. So I know not only my colleagues benefited from this, but I'm hoping other people were watching, those that have considered running for school board and those just want to know how it all operates and what's the relationship between the superintendent and the board. You've given a nutshell version. What are those the cramming books that they call, what are those things called?
Cliff Notes.
Cliff Notes, yeah. Yes. We'll call it Carl's Cliff Notes on school board governance. So thank you again, Carl. As I indicated, we're blessed to have you. All right, well, Madam Clerk, I think that was the only thing on the agenda. We did not have any executive session matters, right, Madam Superintendent? Nothing to discuss, Carl, nothing to discuss in executive session?
No, sir.
All right, so yes, Commissioner Powell?
When we do our survey, should we consider Carl the chair for purposes of rating him, or is that still you?
Well, I don't know. First of all, I didn't even think that this would be a survey kind of meeting, but clearly on the question of did you learn something, that would be valuable, but I don't even know. Do you folks think this is a survey appropriate meeting?
I don't believe we did it for the last PD. I will double check, but I believe it for the purposes of the polls, we were just doing them for special meetings that convene as committees of the whole and business meetings.
Okay.
Well, in that case, let me just say, Carl, I did think it was worth our time.
Absolutely. Absolutely. And Carl, I think you've given this presentation before, have you not?
A little different version of it.
A little different version. I was going to say, I always get something different from it. So thank you very much. Okay. Then I just need a motion to adjourn.
Motion.
Thank you, Commissioner Adams. There's our second.
Second.
Thank you, Commissioner Powell. All those in favor of adjourning the meeting indicate by saying aye. Aye.
Okay.
Aye.
Aye. And then we'll say good night. See you later, everybody.
Yeah.
Good night, Rochester.